Welcome to today's webinar on ESG litigation trends for in-house counsel. For those of you who don't know me, I'm Alex McGregor. I'm a disputes partner here in sunny London, working extensively in this area, and I'm very much looking forward to leading today's session with you all. As many of you know, today's webinar is part of our ESG Global webinar series, which is focused on helping you navigate the complex and increasingly evolving global ESG landscape. But with that in mind, the session's all about you. So we're keen for you to get the most out of it. So I'd encourage you to use the chat function as we go, as we'll pick up questions at the end. But first, I'm delighted to be joined by a very experienced panel of colleagues today. So in a slightly Eurovision-esque way, we'll head over to Anouk in Amsterdam.
Thank you, Alex. Hi, I'm Anouk Rogelle. I'm a partner in the Dentons Amsterdam office. I specialize in corporate and commercial litigation with a focus on mass and class actions.
Thanks, Anouk. We're also delighted to be joined by Kelly Osaka, based in our Calgary office.
Thanks, Alex. Hi, I'm Kelly Osaka, a partner in the Calgary, Alberta, Canada office, and I practice in commercial litigation with focus on class action defense.
And finally, Stephen Watkins joins from the US.
Hi, I'm Steve Watkins, and I'm counsel in the Los Angeles office, and I've been defending consumer products lawsuits for over 15 years, most recently in the greenwashing space.
Very good. Thank you all. So moving on to the agenda, we're going to look at today an overview of global ESG litigation trends and highlight some recent cases across Europe and North America, as well as looking at some regulatory developments that affect litigation risk. But before we dive in, we'd like to get a quick sense of how much ESG is a priority for you at the moment, particularly given the changing global landscape. Neve?
Hello everyone. So on your screens now, you should see a poll that we'd love your views on. We ran this session this time last year, and we also asked this question, and obviously we're keen to know and also to share with you as to how things have changed and how you're now seeing the global landscape. So the question is, how high a priority is mitigating climate and ESG related litigation for your organization right now? And you're choosing between a number of different options, ranging from very high to not a priority at all. So it's lovely to see everyone getting involved, Alex. So we're just going to leave a little bit of space for some final voting. We're heading towards almost 70% of people now who are just indicating how they see the landscape for this area right now. So I'm just going to go 3, 2, 1. Close the poll and share the results with you all. So interesting, Alex, on this one, we're at 48%, either high or very high in terms of their priorities right now. And I think that compares to, it is lower than last year, not unsurprising. We were at 69 on the higher rankings for last year. So just to give people a sense, so hasn't disappeared, still very much a priority, but not as high as last year, obviously.
Yeah, and I can see we also have not our priority this year. So whoever that is that joined, thank you for joining. We'll try and elaborate on some of the priorities you may be facing. But I really think these results is probably a reflection of broader sentiment at the moment, but also just the wide range of other issues businesses are dealing with, such as tariffs and supply chain issues. So even for those who are less focused on ESG this year, thanks for joining. We'll now move on to our global overview now with Stephen.
Hi, just looking at the first bullet here, the Trump administration, it's a new administration, and what we're seeing, especially at the federal level, is a move towards regulation seeking to limit application of ESG factors, and this has carried over to red states in the United States. In contrast, blue states in the United States are looking more towards ESG disclosures in states like Canada and Illinois, which we'll talk about later. notwithstanding what is currently going on in the United States, globally, sustainable energy practices still continues to be a concern, and on both the regulatory level and the consumer level, where we continue to see lawsuits brought by consumers, especially in the United States, seeking to hold corporations to task for what they feel are misrepresentations and deceptive practices relating to representations of sustainability or climate-friendly products. Moving over to the second bullet, sustainability reporting, again, looking at the United States in particular, recently a bill was recently proposed in Congress seeking to exempt certain U.S. entities from reporting requirements outside the U.S., particularly in Europe, and that bill was proposed in March of this year. And turning it over to Anouk.
Sure. Maybe to add on to that, because we're seeing a trend of sort of a dilution of ESG reporting in Europe as well. The ESG reporting was part of the EU Green Deal, as you may know, and most prevalent are probably the CSRD, so the Corporate Sustainability Reporting Directive, and the CSDDD, which is the Corporate Sustainability Due Diligence Directive. I guess in an attempt to streamline these directives and to enhance competitiveness of the European Union in compared to other actors on the global market, the Commission has introduced the Omnibus Simplification Package at the beginning of this year, and that intends to reduce the burden of reporting, as well as delay some of the implementation of those directives. And to put it very briefly, in short, what we're looking at is a postponement of the reporting deadlines under the CSRD and postponement of the implementation deadline for the CSDDD, as well as a scope reduction for the applicability of the legislation. In short, less SMEs will fall under the scope of this directive. Now, those delays in and scoping of reporting obligations will obviously have an impact on the timing of these directives, but it's really clear that ESG reporting obligations and the consequences of failing to comply with them are here to stay and will obviously be an important tool for regulators. Kelly will be talking a little bit about regulatory enforcement next.
Yeah, thank you, Anouk. It's important to keep in mind that, regulatory enforcement and regulatory changes can lag behind public sentiment just because of that time it takes in order to enforce those changes. So it is important to keep in mind the fact that regulatory enforcement is still an issue, whether that's securities disclosure or in terms of greenwashing cases or ethical business practices in your company's supply chains. The other point that Stephen raised is that it's important to keep in mind the regulatory differences or between jurisdictions in which you operate, whether that's even within the US or across other international jurisdictions. And you'll be hearing a little bit more about that in terms of the Canadian perspective. Over to Alex.
Thanks. Under litigation and reputation risk, I think despite the sort of ESG headwinds referred to, the absence of or delay to regulation can itself spur litigation. And we'd expect claimant firms and NGOs to continue to bring ESG claims, to develop jurisprudence in friendly forums, and to pressure companies to take action on a wide range of ESG issues. For example, in the UK, we're seeing an increased focus on supply chain issues at the moment, resulting in litigation. Just turning to the next slide and briefly focusing in on climate change litigation in particular, which is, of course, a very broad term taking into account a wide range of claims. But using this as a barometer, we can see that globally the volume of litigation has increased dramatically since the 2015 Paris Agreement, and there are thousands of cases out there. But the number of new cases have plateaued in the last few years, and are even decreasing recently outside the US. And this isn't so much of a political factor, but it's rather due to claimants' investment in specific cases, and long-running cases in friendly jurisdictions to develop jurisprudence. And we can see that the number of countries where ESG, in particular climate change litigation, is now underway is in fact expanding to include places like China, India, and Turkey. Notably, Brazil is set to overtake the UK and Australia and become the second most prevalent country to the US for this type of litigation. And the claims there are increasingly addressing connected deforestation and climate issues. So we'll turn now for a deeper dive onto the US perspective. Stephen?
Thank you, Alex. Under the Trump administration, change has been swift, and the Securities and Exchange Commission is no different. Last year, the SEC had adopted final rules requiring companies to disclose particular climate-related information, such as mitigation of climate risk and any potential climate risk. However, soon after the SEC stayed that final rule became the subject of litigation that was consolidated in the Eighth Circuit, and last week, the SEC indeed withdrew this final rule. And this is in line with the SEC's chair's recent statement that it's a new era in terms of the SEC. Next slide. In contrast, in my home state of California, California has enacted various ESG bills that mirror the final rule of the SEC that has since been withdrawn. And there has been a challenge to the constitutionality of those rules. It's currently before a federal court in the Central District of California, but so far, the regulation still stays in California. Similar bills have been enacted or proposed in blue states such as Illinois, Colorado, and New York, but we still have to see if those bills will be enacted. But as you can see, there's sort of a distinguishment between California and blue states in terms of their regulations that seek to promote disclosure of ESG factors and mitigation of climate risk, and the current federal climate that is seeking to reduce those requirements. Next slide. Next. Whoop. I think we can go back one or. Okay, no, sorry. So here we're looking at shareholder litigation. Notwithstanding what is going on with the current federal climate, there's still room for shareholders to bring lawsuits based on disclosures and public filings. In this Craig v. Target case in a federal court in Florida, a shareholder brought a lawsuit asserting that voluntary disclosures relating to ESG and public filings were misleading. And key to the decision in that case denying a motion to dismiss, the court held that although a generic disclosure might be sufficient to warn investors of, say, the failure to implement ESG and DEI programs, what was at issue was the failure to mention a specific risk of a 2023 Pride Month program, where you can see this could be extrapolated to an ESG risk, a specific risk that was not disclosed in a public filing. Next slide. We're seeing a lot of pension plan litigation cases out here in the US, and are usually brought under a breach of fiduciary duty theory. Case in point, Spence versus American Airlines in a federal court in Texas, which of course is a red state here in the United States. And in that case, a retirement plan beneficiaries claimed that the investment fund engaged in a breach of fiduciary duty by investing in ESG funds that underperformed. And the legal concept is by investing in ESG funds, that's not always aligned with the pecuniary nature of investing in retirement plans, and therefore there was a breach. And in fact, there was a verdict for the plaintiff after a bench trial. Next slide, please. With this as a backdrop, we're taking a look again at state regulation of red states which have recently introduced bills to restrict application of ESG factors, including Texas seeking to restrict use of those factors in banking, Louisiana seeking to restrict those factors in pension plans, and Florida seeking to restrict those use of those factors in providing financial services to farmers. Next slide. And not only do we see the regulation, we see the state attorney generals in these red states seeking to take this a step further. For example, in State versus Texas, there was a challenge by various attorney generals in red states such as Texas seeking to challenge a SEC rule requiring funds to disclose votes on ESG matters. However, this challenge was rejected by the Fifth Circuit Court of Appeals. And I briefly have highlighted also a lawsuit by against the Missouri Attorney General, who was also seeking to restrict use of ESG factors. Next slide. In contrast, in blue states such as Maine and New Jersey, we have complaints filed by those state attorney generals asserting that various oil companies made misrepresentations about fossil fuel use and its effect on climate change, including assertions that their advertisements portray the defendants as climate friendly. And these lawsuits are usually based under unfair trade practices or negligence theory, seeking to hold these companies accountable for alleged misrepresentations regarding use of ESG. Next slide. Again, back in my home state of California, we have similar ongoing energy litigation brought by the state of California against various oil companies, again asserting unfair trade practices and negligence about what they've stated about the use of their companies with respect to climate change. Those lawsuits are currently consolidated before a court in San Francisco, and there's yet another similar case in the state of Hawaii, which went all the way to the Hawaii Supreme Court. That court allowed the case to proceed, and a petition to the Supreme Court was made, but the Supreme Court denied the review of that case. Next slide. Turning to more energy litigation, a recent case in Eastern District of Texas has an antitrust flavor where various states, again led by Texas, asserted that 3 institutional investors acted in sort of an activist investor capacity, and they're alleging that they have violated federal and state antitrust laws by collectively using their shareholdings to reduce input by domestic coal producers. In that case, a motion to dismiss was filed, and we'll let you know what happens. Next slide. Finally, we're turning to consumer litigation. These are more the flavor of greenwashing claims. There's quite a few of these type of claims in California. There are in other states, but California, I think, has the most. Here we have 2 airline cases, again brought under an unfair trade practices, unfair competition theory. These airlines made claims such as carbon neutral, carbon friendly, or environmentally friendly. One lawsuit was dismissed because it was preempted by federal law, but the other lawsuit has been permitted to proceed. Next slide. These are more consumer product greenwashing claims that we're looking at here. Boyd versus Target Corp is before a federal court in Minnesota. The claim there was that Target Clean conveys that products are free from harmful chemicals and contain only environmentally friendly ingredients. That motion to dismiss was denied. There's also a recent case against Apple asserting false and misleading claims against the carbon neutrality of certain Apple watches. Next slide. Finally, we're looking at a case again in the Ninth Circuit out here in California. This claim involved plant-based wipes, and this is a little more nuanced approach. That court held that plant wipes by itself without looking at any further information, plausibly implied 100% natural plant-derived ingredients without looking at anything further. But to the extent there was an asterisk with that claim, those claims did not state a claim. And just taking a look at the US in general, it's clear despite the regulatory environment, these particular greenwashing and consumer-based claims do show no sign of stopping, and we have to be wary of those. And with that, I will turn it to Anouk and Alex to get a look at how the US and the rest of Europe is looking at these challenges.
Very good. So the first case in the UK I wanted to take you to is Limbu and Dyson, and that defendant is perhaps best known for its vacuum cleaners, to put it on your radar. Now, this was the first post-Brexit case where an English court determined jurisdiction under common law principles over an English domiciled corporation for the alleged acts of an overseas subsidiary. Now, taking a step back to set the scene briefly, the claimants here are workers at two factories in Malaysia who manufacture components under contract for Dyson. So they're not working in Dyson factories per se, but they're supplying Dyson in Malaysia. Now, the claimants brought claims under tort law principles in England against three companies in the Dyson group. Two of those companies domiciled in England, and the third in Malaysia. Now, Dyson challenged jurisdiction of the English courts to hear the claim, arguing that the proper forum was Malaysia, and they initially succeeded. The High Court applied a two-stage process for assessing forum's convenience, finding as part of the first stage of its assessment that Malaysia was clearly and distinctly more appropriate than England as the forum. And they assessed various factors here, such as the role of the English companies in setting group-wide ESG policies, the location of witnesses and documents, and applicable law. And then at the second overarching stage, that there was no real risk that the claimants would be unable to obtain justice in Malaysia. However, the claimants appealed to the Court of Appeal and succeeded, with the court preferring what has since been described as Rolls-Royce, or take your pick, Tesla justice. And notably, when the Court of Appeal came to consider that overarching question of whether justice required that the case should be heard in England, it was the claimants' inability to fund their claims in Malaysia that was found to be a significant barrier to their access to justice there, therefore making England the more viable forum. Now, a few weeks ago, the Supreme Court had the final say in this matter by refusing Dyson permission to appeal. So that case will now proceed towards trial in England in the coming years. Now, I'm mentioning this case for three key reasons. First, in a world where ESG issues are increasingly being viewed differently around the world, claimants and NGOs are still forum shopping for friendly courts to bring claims. And the Dyson case signals that UK courts are open for business because it makes it more difficult for a UK company to challenge jurisdiction over claims arising in countries where a comparable degree of justice isn't perceived to be available by the English court. Secondly, and I've just seen a question about funding for Anouk in the chat. But secondly, the decision of the English courts puts access to justice and especially the availability of litigation funding, so that's funding of claims by third parties in return for a fee, as a particularly important factor in the court's assessment of whether it has jurisdiction. And if you think about this, it creates somewhat of a self-fulfilling prophecy because it signals to the litigation funding market that it's in fact wise to invest in the UK because that will in fact help the courts decide to accept jurisdiction over international mass claims. And indeed, in many countries, the type of no-win, no-fee conditional fee arrangements which are common in the UK are not permitted, and probably few countries will have a more established funding market than the UK as well. And indeed, I think it's safe to say that litigation funding here and perhaps in other places has become a societal and political issue, given the increasing prevalence of mass claims against UK companies here, which has recently been examined by our Civil Justice Council, which has made final recommendations in the last few weeks, in fact, for reform of this area. And just to give you an illustration of the scale of some recent litigation funding in the UK, investment manager Gramercy has invested over 600 million US dollars supporting the Mariana Dam litigation against BHP. That is by far the largest ESG case currently in our courts, being brought by approximately 600,000 claimants. And third, and finally, this claim is a good example of the trend of increased focus by NGOs and claimant firms on the origin of products. For example, where there are allegations of harms in a supply chain. Now, I think this makes it quite tricky and presents a bit of a conundrum for English parent companies managing overseas supply chains, because I think we could agree in principle exercising effective control over supply chains through group-wide policies is generally a good idea. However, the more UK companies talk about those policies, and indeed they're increasingly being required to talk about those policies as part of disclosure rules, they are holding themselves out to be in control and are therefore more likely to receive a claim. I will just conclude by saying that although it may be more difficult post-Dyson to fight cases on jurisdiction, there are still unresolved questions as to the duty of care of UK companies over global supply chains. And I think this question, as well as the returns that funders get from bringing these sorts of claims, will determine the future trend here. Over to you, Anouk.
Thank you. Yeah, I think it's interesting to now maybe highlight a case that was recently ruled upon, which touches on the same subject, and that is the question on whether or not Dutch courts will accept jurisdiction dealing with an environmental harm claim that has taken place across the globe. So in the case of the Stichting Environmental and Fundamental Rights versus Repsol, the Dutch courts have been presented with environmental harm claim against a Dutch, Spanish, and Peruvian entity of a global oil company. And the claim was related to an oil spill off the coast of Peru, whereby the Peruvian entity was operating a refinery close to that location. And there questions of jurisdiction arose as well. So is a Dutch court able to hear a claim against defendants other than the Dutch entity? Like in the UK, the Dutch court did accept jurisdiction over the Dutch entity, but on a slightly different rule, and that is the domicile rule. So Dutch courts will always accept claims against Dutch entities for these types of cases. The question only is, will they accept jurisdiction for the other entities that are involved? The court in this case ruled that was not the case, and it looks at a rule that we have under European and also local jurisdiction rules, and that is that there needs to be a close connection between the claim against the Dutch entity and the foreign entities for the Dutch entity to serve as an anchor defendant. And the court ruled that in this case, it could not make any findings of the involvement of either the Dutch or the Spanish entity with the policies and the management of the Peruvian refinery. And as a result, the court declared itself incompetent to hear claims against the Spanish and the Peruvian entity. As is the case in the UK Dyson case, this ruling says nothing yet about the liability of the Dutch entity in relation to the claim that has been brought. That will be a debate on the merits. So it's definitely a case to watch. But this first jurisdictional decision may give some indications as to what grounds the Dutch court sees to accept liability of a Dutch entity. I did spot the question as well. Indeed, I'll come to it a little bit later, and otherwise we'll have some time for it in the Q&A. Need maybe next slide. When it comes to climate policy litigation in the Netherlands, there have been several notable cases in the last few years, some of which have been considered global trailblazers when it comes to state liability for implementation of climate policies. And the most notable one is probably the Urgenda matter, which is the one on the left of your screen. That is a case that was brought by a special interest group against the Dutch state with the demands to reduce CO2 emissions by 25%. And that judgment was upheld twice in appeal and by the Supreme Court. And that case has really been a template for multiple cases against the Dutch government on climate issues, and as a result, for cases against market parties as well. For instance, Greenpeace and several individual inhabitants of the island of Bonaire, which is a Caribbean island part of the Dutch kingdom, have brought a claim against the Dutch government for the implementation of specific measures to safeguard Bonaire's ecosystem. And that claim was brought under the Dutch class action system. That is a system that's been in place for a number of years, but it's only been since 2020 that it allows for monetary claims to be issued. And that really, together with more ESG regulation, has provided for a catalyst for many of these claims. So this claim was brought under that class action system, but was also brought by a number of individual inhabitants of the islands. And in its latest ruling, the court has declared that cases whereby a class action is started together with claimants that are individuals is non-admissible to the extent that it concerns the individual inhabitants. So the matter will continue as a purely class action, whereby Greenpeace will be the claimant acting on behalf of the overall interest of all relevant parties. And we can see a similar development in the PFAS claim. So that is a claim brought by quite a diverse palette of interest groups. They have brought claims demanding very specific measures, which were quite diverse in their range. So there were claims for the protection of firefighters against wearing PFAS gear, claims for measures to reduce PFAS in surface water, and claims for the protection of natural reserves. And it was specifically the lack of homogeneity in the interest served with this class action that led to the decision of the court to present these interest groups with basically a draconian decision. They would need to decide which of these interest groups can continue with this class action and which of the individual interests served with the reduction of PFAS will be tackled in this class action. So I think overall, when we're looking at these cases, although they are directed at the states, they have been the template for environmental and ESG cases for claimants. And the trend of the increase of those cases remains visible. And these judgments really, I think, provide claimants with guidance on procedural matters, such as admissibility and jurisdiction, in particular in that novel class action system where a lot of jurisprudence on these points is still lacking. And that, I think, in turn gives claimants and NGOs an interest to start ESG litigation, because in the end, both claimants, defendants, and funders obviously want predictability. And lacking predictability really puts a stop on either the funders to fund the claims or for the claimants to start the claims. But with the developments of these cases that I just mentioned, a lot of points that were uncertain are now coming to the surface. So I expect these cases to definitely continue and to feed into cases against market parties. And speaking of those, maybe next slide, Neve. There are two recent cases in the Netherlands that sort of, let's say, piggybacked off these state litigation cases. And those are, I think, the now infamous Shell case and the more recent case against ING. The Shell case, I think, has gotten a lot of publicity. In first instance, the court ruled that Shell had to reduce its global CO2 emissions for scope 1, 2, and 3 with 45% by 2030. And in appeal, that judgment was overturned in full. So the court dismissed the claim to put any obligations on Shell to do anything further than it was doing. And there are quite a few interesting considerations, because the victory for Shell was not a total victory, in the sense that the Court of Appeals did rule that, in fact, individual companies can, in principle, be held to take specific measures to combat climate change, and that human rights can have a horizontal effect and can be invoked by individuals against market parties. But what the court held in the Shell case was that, and that's something important as well, the reason why the claim to reduce CO2 emissions for Scope 1 and Scope 2 emissions was not upheld was that the court said that Shell was already locked into a system of certificates within the EU that was already geared towards a reduction that would meet these criteria, and as a result did not require further orders by the court to comply. And lastly, the court said it could not impose a reduction of Scope 3 emissions with a specific percentage, lacking consensus on industry-specific reduction percentages. And as a result, any such order would be basically the court stepping into the position of the legislator or regulator when deciding on those percentages. Lastly, and this is a little segue to the ING case, the court rules that the order that was requested would probably be ineffective, to the extent that if Shell were to be ordered to limit its Scope 3 emissions, other market parties would step in. Cassation appeals pending on this one, so many of these points are still subject to judicial review, and I think in particular the point on effectiveness, which will play a big role in the ING case. The next slide, please. Because the Shell case inspired the same claimant, which is an NGO, to start a case against ING Bank with similar claims for CO2 reduction policies. And ING is held to implement absolute and sectoral limitation policies geared at, amongst others, its fossil fuel producing clients. Obviously, the fact that ING primarily finances business operations, its Scope 1 emissions would theoretically be much lower than that, say, of Shell. So the debate in the ING proceedings will probably revolve around Scope 2 and Scope 3 emissions. And given the Court of Appeals emphasis in the Shell case on the effectiveness of a measure, it will be interesting to follow to what extent demands against ING would meet that threshold, if that threshold indeed will be upheld by the Supreme Court. So that will be definitely one to monitor. I think, Alex, it's over to you, because you will be discussing a very interesting case that has been going on in Germany.
Yeah, thank you. This one is for me. So the next case we wanted to highlight is the leading European claim for compensation for climate change related damages, which is LUIA and RWE in Germany. And this case has generated some quite significant international attention because it's the first example of a claim for compensation for climate change related damages to reach an evidential determination. And just to provide some brief factual background to bring to life this slide, the claim was brought by a Peruvian farmer, Sol Luia, who's pictured there next to a glacial lake. And he sought damages from RWE, which is a German electricity producer, claiming that RWE should be liable to contribute to flood protection measures at his property, which is situated below that glacial lake in Peru. And he claimed that that was required due to increased flood risk induced by climate change. Now, fundamentally, the claim was based on quite a distinct provision of German private nuisance law, which entered into force in 1900. So at a time when no one was even aware of human-driven climate change. And just to note here, an important component of this claim, which did put it on the international radar, was that the plaintiff argued that climate attribution science supported establishing RWE's liability on a pro rata basis, effectively by assessing its historical contribution to greenhouse gas emissions, which was claimed to be 0.47% on a global basis. And you can see here the extract of the Richard Heat carbon majors study relied on by the plaintiff in this slide. Moving on to the next slide, the court was asked to consider effectively two key issues: whether there was a real and imminent risk of damage to Mr. Luia's property from floodwaters, and secondly, if so, whether RWE could be linked to that risk and was therefore liable to compensate him. Mr. Luia was recently, a few weeks ago, unsuccessful, and the court dismissed the claim. And he was unsuccessful on the first issue I mentioned, because the court found that there was no evidence of a significant flood risk to his property. However, notably, the court found that were there to be an imminent threat to the property, a single emitter in Germany could, in principle, be liable to pay for preventative measures according to its historical share of emissions. So, although the case was not decided on causation grounds, the court did provide its views on some of these issues, and it was largely dismissive of many of RWE's arguments as to whether emissions from one country can be directly attributed to harms elsewhere. Sort of bigger picture, this case, I think, is part of evolving jurisprudence addressing climate-related harms, and it highlights the interconnectedness of global emissions and local impacts. And we're seeing cases more recently involving extreme weather events. I think this case was decided on quite a particular German law civil provision, and it remains to be seen how courts elsewhere would approach these issues. I think an English court would approach the issues quite differently. But all eyes now turn to the US, where, as Stephen mentioned a moment ago, there are damages-based claims heading towards trial in the coming years, as well as a few other similar cases in Belgium and Switzerland that we're monitoring. Back to you, Anouk.
Thank you, Alex. I had a few more cases that deal with greenwashing in the Netherlands, but I'm very conscious of time, and I suggest that maybe I give the floor to Kelly to talk about the few highlights that she wants to talk about in Canada, and obviously available for anyone who's joining this webinar to talk about those offline or maybe later in the Q&A.
Thanks, Anouk. Yes, I'll give you an update on some of the highlights from Canada, and it'll really carry over on some of the themes that we've already heard about in the other jurisdictions. First out of the gate is the Competition Bureau and amendments that were recently made to the Competition Act. So the Competition Bureau has been the most active regulator in Canada when it comes to climate-related investigations. And in June of 2024, so just last year, there were amendments made to the Act itself, which now include targeted deceptive marketing provisions to address greenwashing investigations. And those include statements regarding the environmental benefit of a product that are not based on adequate and proper testing. So that's the language used in the legislation. Of course, adequate and proper testing is not a defined term. It also created the ability for the Competition Bureau to investigate statements regarding the environmental benefits of a business that are not based on internationally recognized methodologies. Again, not a defined term in the legislation. So the Competition Bureau was already out in front of these issues in terms of the number of investigations that it had launched. And now we have these additional provisions specifically targeted at greenwashing, which are vague in the sense that they don't include these defined terms, which was causing a lot of consternation in the market in terms of compliance. Just this past month, within the last couple of weeks, we received guidance from the Competition Bureau, which helps to focus in on some of these terms. The guidance itself states that adequate and proper testing requires actual testing of a product to establish the quality, performance, and reliability. So that means that simply from an evidentiary perspective, relying on evidence of, for example, consumer use over a lengthy period of time will be unlikely to qualify in terms of meeting that standard. In terms of what an internationally recognized methodology means, the guidance suggests that this could include standard-setting bodies, regulatory authorities, or industries using methodologies that are commonly accepted internationally. And that means by recognized in 2 or more countries. So we have a little bit more meat in the bones in terms of how to comply with these new regulations. We still don't have any reported decisions from the tribunals or the courts on how these will be applied, but there is that ability for businesses to proactively conduct assessments on testing of their products in order to demonstrate a due diligence defense. So on to the next slide. This is just a summary of some of the investigations the Competition Bureau has already engaged in, and this was even prior to the greenwashing amendments coming into force. We see here that they've been targeting banks, retailers, and industry associations. And these investigations are really based on public statements, both in advertising campaigns and just simply put on the website. They target statements such as net zero commitments that these companies and associations have made, or statements such as that it was a climate leader in its industry. Now, one interesting response to the Competition Bureau investigations from this slide is that the bank and one of the industry associations responded by actually removing all public information regarding their environmental claims. And this was to reduce the risk of any further regulatory investigation or compliance issues. So we do see that trend here in Canada of organizations sort of backing away from making these public statements because of the regulatory risk. And what we also see is that the regulatory risk leads to litigation risk. So when the Competition Bureau announces a settlement on a greenwashing claim, we can expect, and we have seen, plaintiffs' counsel go off and file class action lawsuits in federal court seeking millions of dollars in compensation. So those are two things to be aware of. The next slide. So I'll turn now to some of the climate change litigation that we have seen. This case is basically pushing back against those Competition Bureau amendments. It was brought by two business associations commenced here in Alberta, and it argues basically that the greenwashing provisions breach the freedom of expression of these nonprofit industry associations as set out in the Canadian Charter of Rights and Freedoms. And basically what the plaintiffs are claiming is that the greenwashing provisions create a significant risk of businesses being subject to a proceeding where the public statements were true or honest or in good faith, and that businesses will begin to defer making those statements in order to avoid the reputational risk and cost. So basically, we see that the businesses are arguing that there is this potential chilling effect on business activities from these types of greenwashing investigations. On the next slide, we have the Sue Big Oil campaign, and this is similar to what Stephen was talking about in terms of the ongoing lawsuit in California, where here we have a plaintiff side class action seeking to bring a claim against energy companies, claiming that they knew that burning fossil fuels would result in climate-related damages, which have been impacted by the province of British Columbia. The campaign has been moderately successful in that 10 municipalities in BC have signed on to contribute $1 per resident to funding this lawsuit. So that's something else to keep an eye on. Next slide. The most advanced claim here in Canada in terms of ESG related cases was brought by a group of young people against the province of Ontario. They claimed that the alleged failure of the provincial government to comply with the legislation it had enacted to combat climate change breached their rights under the Canadian Charter of Rights and Freedoms. So basically the province had enacted these climate greenhouse gas emission targets, and the youths were saying that they were too low compared to international standards. So this has gone up to the Ontario Court of Appeal, which recently overturned the lower court decision, which had found that the lower court mistakenly treated this claim as creating a positive right or being a positive right case on behalf of the plaintiffs. The Court of Appeal instead found that the claim sought to ensure that the target emissions that the government did set were compliant with the charter, so not actually creating a new right on behalf of citizens. The Court of Appeal actually declined to make any sort of decision on the merits. Instead, it sent it back down to the lower court for redetermination, and the Supreme Court of Canada has recently denied the leave to appeal. So the last topic I wanted to chat about was other legislation, and this is leaving the E and moving over to the S in ESG, just highlighting the fact that in 2023, Canada passed its first law requiring organizations to provide annual reports on efforts to prevent and reduce the risk of forced and child labor in their supply chains. Canada was one of the first jurisdictions to require reporting on child labor as well as forced labor. Since the legislation has come into force, Public Safety Canada has released guidance on the legislation to clarify that the reporting obligations are not intended to apply to entities that are solely engaged in the sale or distribution of goods, despite the fact that that wording, as you can see on the slide, is actually in the legislation. This means that the only entities that are required to comply with these reporting standards are those entities that produce goods anywhere in the world, import goods into Canada, or control entities that engage in those activities. So again, these are early days for this type of legislation, but something to keep an eye on in terms of ongoing regulatory investigation and potential litigation. I will pass it back over to Alex to talk about some key takeaways.
Thanks very much. So standing back from our whistle-stop tour around a number of regions today, what does this all mean for you and your in-house legal teams? Well, I think the first concluding comment is really that ESG is both a local and international issue, and its applicability will be fact-dependent to your footprint. Particularly in the US, we're seeing an uptick in anti-ESG claims, which raises some sort of countervailing risks to consider. And those claims include challenges to ESG-based investment decisions. But from a 30,000-foot level, I think we can expect ESG claims to continue to be brought around the world to influence corporate behavior, to influence the transition to net zero, and to address those intractable issues around legal responsibility for diffuse climate and environmental damages. And this is likely to continue in the longer term. For in-house lawyers, I think horizon scanning and mapping risk across your business remains vital, even if your attention is being pulled onto other issues, which should be forgiven for in the recent climate. And that should take into account key risk factors like where you're registered, your supply chain, and which entity sets your group ESG policies. ESG and the language used around it is now a pretty fine balancing act. I think indeed you can expect increased scrutiny of your disclosures, advertisements by a range of sophisticated actors with differing interests. And as we've heard, recent legislation amendments suggest an increased regulatory focus, particularly on greenwashing, which is a particular risk for consumer-facing businesses, of course. And regulators are harnessing AI and other tools to bring more proceedings in this space, which again enhances the risk. I'll just conclude by saying that while sustainability disclosure obligations have receded in some places, they seem to be here to stay in Europe and possibly other places as well. And ensuring compliance and accuracy here, as well as deciding what the right level of disclosure is for out-of-scope companies, is a risk area in itself. So we'll conclude the presentation part of today here and come on to a Q&A. Feel free to drop any questions you have for our panel into the chat or direct message us. I think there was one question, at least in the chat already. Stephen, hand over to you to marshal this part of the conversation.
Thank you, Alex. Anouk, I will pose to you this question that you touched on earlier. What types of greenwashing enforcement actions or cases that you're monitoring?
Thanks, Stephen. Yeah, maybe since we're at it, I could maybe pick up on the question that was put in the Q&A, which was also directed at me, which I think is the question if the fact that there is third-party funding in the Dutch market and the class action system would be seen as a threat to the business climate of the Netherlands. I think it's a question that you can ask more generally on any of the jurisdictions that we touched upon. I think my answer would be for the Netherlands that I think a class action in an system in and of itself and the access to third-party funding does not equate to a less friendly business climate, in the sense that there are several bigger markets in the world that already have an established class action system, and I guess litigation risk is something that you would just factor into deciding on where you would want to establish your company or your business. But at least it's something you can factor in. What I think does lead to a less friendly business climate is uncertainty. And I think that currently in the Netherlands is indeed a bit of a problem because our class action system is quite novel and it still has a lot of uncertainty on points of procedural law, so admissibility, jurisdiction, but also on more prevalent cases, which is what is the scope of damages that you can claim, what types of actions can you bring, what defenses can be put up, and what would we expect funders to look at when they want to fund these types of cases. So that, I think, combined with sort of wavering messages, at least in the EU, from an ESG regulation perspective, I think is what could make the EU or the Netherlands at this point in time a little bit less of a friendly climate. But I think that more goes, as I said, more to uncertainty than the existence of the system itself.
I just had one just slight addition from a UK perspective. It's very much a debate in the UK at the moment as well. Recent studies have suggested mass actions cost UK businesses some £18 billion. The Civil Justice Council has recently released quite an influential report, which the government is considering, where they've proposed some light touch regulation in the space, but also to reverse a important decision called PACAR here, which called into question the enforceability of certain types of funding arrangements. So watch this space in the UK. The government will probably take some action on this in the next 6 months to a year, and that may change the market in the UK somewhat.
Just looking at the chat while we're waiting, I do have a question for you, Alex, going back to something you said earlier. Do you see claims for climate change compensation in the UK courts like you have seen in Germany?
Yeah, I mean, we haven't seen any yet, certainly not claims for compensation. We've seen lots of judicial reviews and challenges to government policy on, meeting Paris Agreement targets, etc. I think the fundamentals for such cases exist here in terms of, well, we just discussed funding as one of them, but also our sophisticated claimant bar and the willingness of our courts to accept jurisdiction over claims arising overseas. I think there'll still be some doubts about how an English court would approach those issues. The German court didn't really have to consider under German law things like foreseeability, remoteness, duty of care, as well as the but-for standard of causation that English courts prefer. So I think the ingredients are here, but there are still questions, I think, about the viability of those claims.
Thank you. And Kelly, here in the United States, we have a lot of consumer-based litigation on these issues. Can you speak to the amount of litigation you see in Canada on these issues from consumers?
Yeah, Canada follows the same trends that come up from the States. It just takes a little bit longer for them to sort of work their way up here. So I spoke about the municipalities, class actions that hasn't even been filed yet. I would expect to see more class actions coming out from the Competition Bureau amendments, and then probably as well with the consumer protection side that you talked about and the unfair trade practices. But it's still early days in terms of those types of class action claims here. Our most active jurisdictions for class actions are Quebec, Ontario, and BC. So that's where I would expect to see them filed.
Okay, thank you.
Okay, well, as always, time is short for these things, but if anyone in the audience has any questions, please feel free to reach out directly, or if you'd like a copy of the slides as well, we'd be more than happy to have a tailored discussion on any of this. Thanks very much to my fellow presenters, and of course, most importantly, to our attendees today. Have a good rest of the day, all. Thanks very much.